Okay.
Very nice.
Okay. Thank you so much, everyone who has joined this session, and would like to welcome you to today's discussion, whereby we are hosting Dr. Sangyun Lee from Kyoto University, who was a PhD in law from Korea University, which focused on abuse of economic dependence. And as we all know, that the FCFTA competition protocol seeks to regulate abuse of economic dependence in the digital market landscape. So today, Dr. Lee has written a lot about how Korea and Japan have sought to regulate their competition policy, with Japan adopting the DMA-like rules, and Korea going through what he refers to as a roller coaster, from regulation to self-regulation, again to regulation, seeking to adopt the DMA-like rules, and then back to amending their competition law and introducing provisions relating to legal assumptions and so on. And then the question is, like, he argues that although we have global rules like the DMA regulating digital markets, other countries have to really be cautious and take into consideration the market conditions in digital markets, and then the issue relating to not stifling innovation. And so I don't want to say a lot because I don't know a lot about Korea, and therefore this is a chance for us to learn. And Dr. Lee, we are really excited and we are really humbled to be with you today and to have an opportunity to learn from you and to also share your knowledge with us. Thank you so much and welcome.
Thank you very much. It was a really brilliant introduction. I feel that it's actually a little bit more than the reality. And, I feel really that I'm a really good person, but thank you very much. And I feel really great. And thank you for inviting me. And I'm really happy to be here and to be given an opportunity to share the Korea and Japan's situation, and given an opportunity to contribute to the African society. And as we talked previously, I mean, I have been really interested in the recent developments of African competition regime. So actually, I think that I'm the person who need to learn from you, but luckily I'm here to share my knowledge here. So I think this maybe not be the just the end of our communication. I think just the beginning of the. I hope this would be the beginning of our long discussion. Uh, okay, I'm gonna. Okay, let me just start. Right, jump into the topic. I'm so sorry. I'm sometimes too much talkative. Okay, let's move on to the overview. By the way, audience, I mean, if you have any questions during my presentation, you can just feel free to intervene. I would be happy to discuss in the course of my presentation. I don't care. And then my presentation, if you don't stop me, it's going to be really short. And then the current slide deck will be uploaded to the LinkedIn and my SlideShare page. You can check it directly, and then access many links in my slides like this. I mean, you can just click this button and access to the sources. So just keep this in mind, in your mind. And I hope this would be any help to your research. Okay, overview is just the introduction page, and but I don't think it's really needed to discuss because Dr. Vela has already explicitly and really well summarized the aim of today's session. And what I want just to add is that to remind you of the fact that Japan has recently introduced a platform regulation, which is called the Smartphone Act shortly. But some people argue that it's a kind of a DMA but I would say that it's more focused version of the DMA, targeting competition concerns only in the smartphone software ecosystem. Meanwhile, Korea, 3 months later, after the Japan's announcement of the adoption of the Smartphone Act, the Korea's government announced that it scrapped its previous plan to introduce the proposed Platform Competition Promotion Act, which modeled after the DMA or the Germany's Section 19A. Sorry, this is my typo, but what I wanted to say is the step 19A gave away and instead pursue amendment of competition law, introducing legal presumptions of dominance and some dominance for platforms and of their anti-competitive practices. So today, in my short presentation, I'm going to share that what is happening in Korea and Japan and what's the future aspect, what's the future prospect, and I want to set the stage for further discussions with you on the so-called global regulatory trends in digital platforms. Well, I'm going to start with the market situation, but as we all know that this part in the data are really important, but the thing is that it may be really boring, so I'm going to quickly pass because what I want to say here in these slides is that the Korea and Japan's their markets are also quite concentrated, but at the same time, you can see many competitors still growing from the concentrated markets. So, for example, as you can see here, well, yeah, mobile OS market. Look at this market first. As you can see here, in the case of Android, Google's Play Store holds more than 90% shares, which can be seen as a really strong dominance. However, One Store, it's a local app store market, is relatively small, but it's growing very gradually. So this may affect the Korea's policy choice later. And we will see in the end of our my presentation. And the one more thing to note is that in Korea, even Google doesn't hold the dominance in search market. Of course, this data was from 2016. So now Google holds more shares. It amounts to 40% or 50% as far as I know. But the Naver is still holding the first strongest position in the market. Okay, then let's move on to the competition law and the regulations, the institutional framework of Japan first. Japan, its competition law is called Act on Prohibition of Private Monopolization and the Maintenance of Fair Trade, shortly called Anti-Monopoly Act. And here in this presentation, I will say that as AMA. AMA comprises has many traditional tools like collusion and monopolization and merger control provisions. But in addition to them, it also has unfair trading practices prohibition, which includes abuse of a superior bargaining position. And Vela has kindly mentioned, I wrote about, when I was PhD, I wrote about abuse of economic dependence, and this is called abuse of a superior bargaining position in Korea and Japan. And this is one of the most notable features of Japan's competition law, as well as Korea's competition law. And JFTC, Japan's competition authority, usually use a commitment measure and injunction, as well as a recommendation, which is unofficial, but which also works really well in Japan. And criminal sanctions exist, but rarely used. So you don't need to think it very seriously. But the story may be different in Korea. Korea uses criminal sanctions very often. So you have to keep this in mind, keep this difference in mind, and then this would be really helpful to understand the Korea's situation. In addition to the AMA, Japan has many tools like the Subcontract Act and the Freelancer Act, which has recently adopted. In addition to them, as we just discussed, as we have already seen, Platform Transparency Act was introduced, and the Smartphone Act was also introduced very recently. Platform Transparency Act is I think you may have heard about European Union's P2B regulation, which is focusing more on the transparency. This regulation is very similar to the P2B regulation, but the scope is much narrower than the P2B regulation in Europe. And the actual enforcement of the Platform Act, the Platform Transparency Act, is this act looks like a self-regulatory regime, which means that voluntary-based governance. So from the perspective of regulation, this law may not be really important. Okay, then let's move on to the Korea's institutional framework. Korea's competition law is called the Monopoly Regulation and the Fair Trade Act. Shortly, it is called the MRFDA. And like Japanese competition law, it includes many traditional tools like the abuse of dominance, which is a little bit different from monopolization. But nowadays, it doesn't produce really big differences. You can just imagine the differences between the US monopolization and the EU's abuse of dominance. And also, the MRFDA has a merger control rules. In addition to them, it also has unfair trading practices like Japan, including abuse of a superior bargaining position prohibition. But differently from Japan, unlike Japan, KFTC usually use administrative fines and cease and desist orders instead of recommendations or commitment procedures, which means that they are really active in finding infringement of MRFDA, and they are really aggressive. And also criminal sanctions, as I mentioned earlier, criminal sanctions are really actively enforced. So, which means that the competition authority is not the sole authority who can enforce the MRFDA. The criminal authority, prosecutors, can also enforce this law. Of course, technically upon the KFTC's referral, but I'm not going to explain the details of the institution, but you can just keep this in mind that a criminal authority can also intervene in the market, whether it's digital or not, but it doesn't matter. You can just intervene in the market at its own discretion. So MRFDA, the Korean competition law, is already strong, but it also has so many tools to address competition issues. Here in this context, competition should be regarded as a really broad concept. It includes vertical competition. It is not only about horizontal competition. It is more about exploitation and unfairness. And Subcontract Act and the Franchise Act, the Large Retailers Act, Agency Act, and the Terms and Conditions. There are so many acts and special rules to complement the MRFDA. And in addition to them, there is another specific platform sector specific law, which is called In-App Payment Act. You may have heard about this law perhaps 2 or 3 years ago, that because Korea was the first country to adopt regulation to sanction to regulate the Apple and the Google App Store markets. unfortunately, this law is not enforced very well so far, but perhaps within a few months or within a year, we will see the actual enforcement case of under this act. And as we discussed in the beginning of the presentation, the KFTC recently proposed amendment to the MRFDA. And the latter part, I'm not gonna discuss the latter part, but maybe this may be really important for someone who are really interested in the platform regulation in a broad sense, because Larger Retailers Act, thanks using this amendment, the KFTC is trying to expand the scope of the Larger Retailers Act so that it can regulate e-commerce platforms as a traditional retailer. But this issue more related to late payment. So I'm not going to discuss in detail about this law. I'm going to focus more on the amendment of the MRFDA. Okay. Yeah, I prepared these slides to explain to you about unfair trading practices in Japan and Korea. But in the Q&A section, if you are interested in, please ask me questions about these two rules, because it may be boring for someone who maybe not very interested in the unfair trading practices.
It's not boring. Would like to know more.
Really? Yeah. Okay. Well, thank you, Bella. Actually, it's really important because our views of dominance position, we have it. In Japan has a monopolization provision, but what actually used in the reality more often is unfair trading practices prohibition. It is really complicated, but to put it simply, there are roughly two types of violations. The first is lessening free competition, and the second is, as you can see here, right side, abuse of superior bargaining positions, theory of harm, infringement of the foundation of free competition. So yeah, there is another type of theory of harm, which is called unfair method of competition, but let's forget about this part. Okay, let's focus on those two parts, lessening free competition and infringement of the foundation of free competition. The latter part can be translated into exploitation. So what is the lessening of free competition? It is the theory of harm for discriminatory practices and unjust pricing and tie-in sales and conditional trade, and also interference with the competitors' trade or business operations, as you can see here in this table. You may have heard about the United States, the old theory of incipiency violation of the Sherman Act, right? At an earlier stage, the competition authority can intervene using the tool of the FTC Act, Section 5, unfair method of competition. So it was once discussed in the United States, but as far as I know, it is not seriously considered as a real theory of harm that can be used in the reality. But here in Japan, it is still alive, which means that JFTC can intervene in the market even if there is no dominant company, even if there is no monopolist company, and even without a very serious economic analysis. So you can just analyze the, what can I say? Yeah, it's a really softer version of the monopolization or abuse of dominance. So if, let's say, there is a 20% or 30% market share company, and you can sanction this company with these tools. So at an earlier stage, the JFTC can sanction and stop anti-competitive practices of a company. So For this reason, it is really often used by the JFTC, the competition authority in Japan. And in Korea as well, we has the same or very similar rules to that of Japan. And as you can see here, left side, Article 45 of the MRFDA stipulates many types of unfair trading practices, but let's focus on the black boxes: the refusal and discrimination, exclusion and restricted terms, and unfair support. Yeah, unfair support is a totally different issue. So let's focus on the 4 types of violations of unfair trading practices. They are lessening competition type unfair trading practices. So the KFTC can use these tools to intervene in the market at an earlier stage. There may be no really dominant companies in the market, and there may be no really serious anti-competitive effects, but using these tools, the KFTC can sanction a rather small company from engaging in anti-competitive practices that may lead to really explicit anti-competitive practices. Of course, the KFTC uses abuse of dominance position as well, but it only uses it in really serious cases, because the law gives the KFTC stronger power, remedial power, and higher fines in the case of abuse of dominance. But in unfair trading practice cases, the level of fines that the KFTC impose is rather limited. So the KFTC uses these tools to handle relatively small cases at an earlier stage. And if you look at the red boxes, inducement and forced dealing, ASBP, as I mentioned, it is abuse of economic dependence and interference. These are unfair types of unfair trade practices, and which can be used without anti-competitive effect analysis. You can use them like what you may say, unfair competition or exploitation. So yeah, abuse of a superior bargaining position is really liked and loved by the KFTC because it's really handy. It's a really efficient tool to address the issues at an earlier stage as well. You don't need to analyze the market condition. Of course, you have to analyze the context and market conditions, but roughly, you don't need to define the relevant market, and you don't need to focus on the explicit anti-competitive effects of a problematic conduct. You can just focus on that someone is exploited by a superior company, his practices using the dependent relations. So as you can see here, imposing this advantage type is very often used by the AFTC. So please keep this in your mind, because this will be a lead to the actual consequences of enforcement record in Japan and Korea. As you can see here, and this list is exhaustive. I mean, they import these cases, and not anymore, but these cases, well, quite a lot, right? And, compared to, for example, the European Union. But the thing is that, as you can see here, as far as I know, every case has closed without infringement decisions. Almost every case was closed with commitments and voluntary measures. So the JFTC touched upon problematic cases in a really softer way. That's what you have to in your mind. I mean, JFTC. So many people are criticizing that the JFTC is too prudent or too soft because there are so many really big companies and who don't care about the market mechanism and tend to distort the market mechanism to increase its market power and to exploit its customers in the market. But the JFTC needs to issue stronger sanctions against them. There is a certain group of arguments like this. Of course, on the other hand, some other practitioners or scholars praise the JFTC's approach because it can handle cases and within a really short time frame. You know, you can just resolve because you don't need to write the full decision, which may amount to 100 pages or 200 pages, 300 pages. If you look at the Google shopping decision, and it's terrible, you know, for scholars, right? I mean, you have to read all the papers, all the pages. But anyways, if you close the case, if you can close the case with commitment, you don't need to get involved in a really dirty fights before courts, and you can just close the case with effective remedies. So, but yeah, it is also questionable whether the remedies can be seen effective or not. But anyways, yeah, I just want to say that there is a certain, there is a group of scholars who praise the JFTC's approach for their speed and effective remedies. On the other hand, let's look at Korea. You know, Korea is a little bit different. The very recent case is the Kakao Mobility case, which was out in October 2024. And in this case, it was the abuse of dominance case. And the KFTC sanctioned the platform, the taxi hailing platform, and also imposed fines and imposed orders, and also made a criminal referral, which means that criminal authority can intervene and investigate this company again. And of course, the KFTC made a complaint, a criminal complaint, only against the legal person, but it is very not uncommon here in Korea that in the process of investigation, criminal investigation, the criminal authority finds a new allegation relating to individuals like CEOs or personnel who are in charge of the business strategy, and then charge them before the court. It's really not uncommon here in Korea. So what I can say is that it's not the first time. I mean, as you can see here, for example, yeah, Coupang case was also criminally charged, as you can see here, the second case. And yeah, where's the yeah, there are many more, not many, but yeah, compared to Japan, there are many more cases that have been referred to the criminal authority. So what I want to say here in this slide is that Korea's competition authority has never been suffered from the under-enforcement. You know, they are really active, even stronger than the European Commission or any other authorities in Europe. And they can use criminal sanctions, and then, of course, who can use the criminal sanction is the criminal authority, prosecutors, not the competition authority. But anyways, the government can use it and they have never been suffered from under enforcement. So you have to keep this, keep the institutional backgrounds and the market backgrounds first, in order to understand why Korea adopts a different approach and Japan took quite a regulatory approach. As I already explained in the course of explaining the previous slides, Japan takes a really very cautious stance and enforces the law with great care. And the number of investigations not low, but the most cases are closed without finding breaches. Japan's approach can be raised for its speed and for being less restrictive on businesses, but the risk of a false negative is really high. And on the other hand, Korea adopts a more experimental stance and enforces the law very actively. And as a consequence, the risk of a false positive is really high. That's what I want to say here in these slides. Okay, here, yeah, if you're interested in how active the Korea's competition authority enforcement is, then you can just refer to this news article, which explains the how many times and how much the KFTC imposed the fines. The next slide shows that Japan's path to a platform regulation. Now, finally, sorry. If you look at this slide, you realize that Japan has taken really step-by-step approach, right? I mean, in 2018, it formalized a study group, and the Japan's government published the fundamental principles for regulating digital platforms. And in October 2019, it published a report, and following that, it published guidelines about abuse of a superior bargaining position regarding data abuse, which was inspired by the Bundeskartellamt Facebook decision, I think. And yeah, as we already discussed, the P2B regulation was adopted in Japan as well. And then Digital Markets Act also inspired the Japan to introduce act on the promotion of competition for specified smartphone software, which is called the Smartphone Act. But this was not coming out from the scratch. There was a preparatory work, which is called Report Regarding Mobile OS and the Mobile App Distribution. And so thanks to this report, many people realized and anticipated that the JFTC would enact a platform regulation focused on the mobile OS and mobile app distribution issues. However, Korea is a little bit different. I don't know what makes such a really huge differences between Korea and Japan, because we share many cultural backgrounds and we share many institutional similarities. But yeah, let's look at history. In May 2020, the task force for developing platform guidelines was established by the KFTC. But suddenly, in June, the KFTC announced that it will initiate a platform regulation. So it will introduce a platform regulation, and many were surprised by the announcement, because what people thought was that the KFTC would publish the platform guidelines, not the regulation. But the KFTC, the chief of the KFTC, just announced that we're gonna make law, not the platform guidelines. It was really quite shocking. And only 3 months later of that announcement, the draft bill was actually released. It shocked many more people because during these 3 months, no one knew that what happened inside of the KFTC and who drafted the bill, I just assumed that the KFTC or high-level enforcers were inspired by the European Union's P2B regulation, and as we have already seen, Japan's enactment of the P2B-like regulation, which we have called Platform Transparency Act. This initiative surprised other governmental agency as well, which is called the KCC, the Communication Authority, and it proposed a bill for the Online Platform Users Protection Act, but the content of this act is very similar to that of the KFTC's bill, the Online Platform Fairness Act. The only difference is that KCC will regulate the market, not the KFTC. We're gonna take the power, and so as you can imagine, that there was a really serious conflict between the KFTC and KCC. So the legislative process, luckily or unfortunately, was really dragged, and those two bills failed in being enacted as a law. But in the course of the conflict, the KCC managed to getting a small victory. As we have discussed, the case there was a App Store Act in Korea passed in 2021. This act gives the regulatory power to the KCC, and so KCC pushed for this act, and then they were really happy to have the regulatory power to sanction Google and Apple in the App Store market. However, unfortunately, as I have already discussed it in my blog post, they have not been able to enforce the law because they have never handled any global issues before this, because and they are now fearing getting appealed by the global companies and losing before courts. So anyways, let's move on to let's focus more on the platform regulation. And in March 2022, there was a presidential election, which means that the government has changed, and then the members of the policymakers, the group of policymakers was really significantly changed, and Korea tried to test the self-regulatory regime, and which ended in failure anyway. In January 2023, finally the KFTC's platform guidelines were out, and the KFTC seemed to focus more on the competition enforcement rather than the regulatory regime, because the government atmosphere has been changed, and it focused more on the issue, market competition issue rather than the regulation. So it formalized a task force within its agency. But suddenly, in October 2023, the President Yoon was really unhappy with the dominant platform's behaviors. So it criticized Kakao T especially, and ordered the KFTC to make a solution. And 1 month later, the KFTC presented a renewed proposal for platform regulation titled the Platform Competition Promotion Act, which modeled after the German competition law or the European Union's DMA. The other developments are, as you can see here in this slide, the KFTC tried to push, but it failed, and it revived it, but anyway, it failed again. So in September 2024, it decided to scrap the plan and renew the proposal to amend the MRFDA. So yeah, Japan's Smartphone Act, the details are like this. So if you're interested in, just you can check the details here in this slide. And the regulator scope is really narrow, and the prohibitions and compliance obligations are included, but it can be compared to the DMA's similar provisions, but still it is a little bit different from the DMA, and there are also sanctions and remedies. So, and Alba and I once wrote a short piece about Japan's Platform Act like this. So I just borrowed the table. And this table is actually a work of Alba, so I really thank her. And then I hope this table would be of any help to you or research. In Korea, it's just a proposal, so the details has not been disclosed, but based on the press release, we can say that the KFTC would pursue some legal presumptions of dominance and presumption of anti-competitive behavior for dominant platform practices. And so in addition to them, interim measures to speed up the enforcement and increase of fines to up to 8% of relevant turnover from the current 6%. These are now proposed by the KFTC. So it remains to be seen whether the Parliament, the Korea's National Assembly, adopts and receives this proposal. But the thing is that, as you can see here, in Korea, now the opposition party is really unhappy with the proposal. So it is now pursuing its own initiatives to regulate platforms. But I don't think they are really likely to be passed. But anyway, technically, it's possible to be passed. And Japan is now expanding the enforcement team. As far as I know, reportedly, the team currently has 14 staff members, and they are now thinking of adding 35 more new staffers. And if you include the part-time data analyst and many other specialists, they will totally have 60 members in their team, which shows that they are really serious in the enforcement of the Smartphone Act. Okay, final remarks is this section just shows that what I think about Japan's and Korea's experience. I don't want to read all the characters, but what I want to focus on one concept, the institutional isomorphism. It's very natural that different jurisdictions have different institutions, but isomorphism, this theory explains that even in different contexts, jurisdictions may have similar rules. This may be because of coercion or a normative mechanism or just a mimicry. And I think that, yeah, mimicry, I mean, sometimes copying the foreign models can help secure legitimacy of a policy choice, but it doesn't always guarantee success or effectiveness of it in the practice. So we have to be really careful, and then we have to make a policy choice according to the market situation and institutional settings. Thank you very much for listening. I'm sorry if I bored you.
Oh, no,
the audience, all the audience. Thank you.
Yeah, the information was very relevant, and I felt like we needed more and more and more explanation. But the issue is we only have 1 hour, 15 minutes. It's almost over. Thank you so much for the presentation. And I also shared your blog article, which I know most of us will read. And I've seen my colleagues from the FCFT Secretariat, so I know they were really taking notes and so on. So I have a few questions before I read a question from the chat, which you can also read. And one of the things I observed in both the Japan and the Korea competition policies that they have the unfair trading practices, provisions, which I think they have provided a basis upon which the competition authorities have been able to investigate and enforce competition law-related issues in digital markets. And in the African setup, most of the competition authorities do not have directly a provision on unfair trading practices, although indirectly we have some provisions that speak to unfair trading practices. And I just wanted to know if this kind of provision is very important for competition agencies that are seeking to amend their competition law in order to tackle competition issues within the digital markets. And then another issue that I found surprising is that if Japan was really following the EU developments from the DMA to the platform to business platforms, platform to business regulations of 2019, then why is Japan too cautious? Why is it taking a very cautious approach? And also, in your last slide, you've given us some of the issues that we really need to consider. And I would like to know when it comes to Korea, because as you noted in both your presentation and your article, there was a lot of contestation. And there was something which you mentioned, like a top-down approach that the KFTC was using that you've not mentioned in your presentation, which I found so important for the African competition agencies and the FCFTA, and lack of consensus building among the actors. And one thing you mentioned in the blog is that it's like the KFTC did not prepare the businesses by having maybe a market inquiry or a report that will form the basis of adopting a legislation, or something that would really identify why did we need this kind of regulation. And if you just tell us some of these conditions you think can explain the roller coaster kind of regulatory framework in Korea, I think it will really be important in informing the African competition agencies as we seek to adopt regulations on digital markets.
Okay. Thank you very much. As far as I understand it, there are 3 questions, right?
Yeah, 3.
And the first one is about unfair trading practices, and the second one is about Japan's prudent approach, and why is that? And third one is about Korea, and then perhaps it may be very
Why
relevant
did Korea
to
go wrong?
the top-down
Yeah.
approach, and then the lessons from the Korea's situation, right? Do you mind
Yeah, you
if I
can answer
share?
the other question as well.
Okay, yeah. I will start with 3 questions first, and then thank you for the question, Kumar, Miss Kumar.
Yes.
Can I just share my slides again? Because it may be more handy, more convenient to deliver my message. And then, yeah, here, unfair trading practices. Yeah, as we have already seen, the JFTC has used the tool of unfair trading practices very often. And then KFTC also has used the tool very frequently. So, which showed that the importance of unfair trading practices is really huge in those 2 jurisdictions. And Vella made a really great comment and made a really good point. Well, I think I want to start with economic history of the Korea and Japan. As you may know, I mean, Korea and Japan have experienced a really rapid growth, economic growth, which means that the government had a really strong grip over the company, over the economy, and then it used industrial policy tools, and they were really successful. And it was really successful, but on the other hand, there have been many problems coming from the government-led economic policy. For example, economic inequality and between companies and economic actors were really exacerbated, and then people were really politically upset about the really not balanced imbalance of their situations. So for example, someone is really rich and someone is really poor, and I believe that against this backdrop, the Korean government used the Korean government and the KFTC use a tool of unfair trading practices to handle the distribution issues in a really effective and in a really efficient way, instead of using the abuse of dominance or other collusion tools, because it had really limited resources back then. For example, just 20 years ago or 10 years ago, even 20 years ago, the KFTC had not enough resources to enforce the abuse of dominance provision in a really fine way, in a really elaborated way. But in that situation, unfair trading practices were really helpful to, handle the case without facing serious backlash from the court and many other scholars. It's just unfair. If you can just say that something is unfair, then it's way more convenient and way better than saying something is anti-competitive without any reasoning. So the KFTC used this tool in a really efficient way. And I believe that the FTC, Japan's situation is a little bit different, because Japan still, I feel that the Japan's government still favors an industrial policy approach. But anyways, let's just focus on the Korea's situation. So if you look at the Korea's experience, you can think that in some jurisdictions which are still developing and which are suffering from the lack of human resources and suffering from the lack of consensus about the beauty of the competition policy, I think unfair trading practices can be a really good alternative to other traditional competition tools like abuse of dominance or monopolization or module control or collusion or cartels, because the competition authority, the government, can handle this case in a really efficient manner. But it's also really risky, because which also means that the government can handle all the cases at its own discretion. And if the government's discretion is too broad, then there's always a risk of abuse its power. Government can abuse its power. So that's the reason why many Korean scholars nowadays criticize the use of unfair trading practices, because there is a tendency for the KFTC to use unfair trading practices instead of the abuse of dominance provision, even if the case is abuse of dominance, because it doesn't want to lose before courts. So if you think that in spite of the risk, you really think that this jurisdiction needs a really efficient tool, then unfair trading practices may be a good choice, I think. But it really highly depends on the context, specific context. That's what I can say about unfair trading practices. I hope this may be enough for your question. And the first question, and the second question maybe is about why Japan is so cautious. I'm still questioning myself. Maybe cultural reasons or institutional reasons, or the personnel and the enforcers, their motivation may be different. I remember that you wrote you presented about African situation using the theoretical framework of rational choice, right? So it was really impressive. And also, I am thinking of analyzing or researching about to find out the reasons why Japan, the JEFTC, takes a really cautious approach. I think interviews or qualitative research may give us a brighter answer, a little bit brighter answer, but for now, I don't have a really proper answer. So what I can say is that we need more research, not only from the perspective of law, but from the perspective of rational choice and many other um, um, social sciences methodologies. And for the third question, and the top-down approach, yeah, I think you already have an answer, and it's really, for me, it's really good to repeat repeatedly to share the key insights of my blog post that has already been published on the truth on the market. As you can see here in the footnote, as for more details, see the following article, Sangyun Lee, Lessons from Korea Roller Coaster Ride. Okay, as you can see here in this slide, the KFTC, I don't think that the KFTC really intended to abuse its power policy, or I don't think that the KFTC really wanted to um, just to copy and paste the DMA or the P2B regulation. Instead, I think that there was a pressure, a political pressure from the public and from the politicians and from the president. So they were not able to resist effectively against external pressures. So I think this may be one of the insights that I can share with you, that competition authority, if it is really vulnerable to external pressures, then what we can achieve from the competition authority's initiative is very limited. And the second one is, as I wrote in my blog post, is that and also as you correctly mentioned, Bella, that consensus building approach is really needed. Let's just assume that KFTC has a sufficient level of discretion and independence. Even in this case, the KFTC needs to first to analyze and to check out the facts very correctly, whether the market is really distorted, whether the market fails, or any other institutional tools. If there are any other institutional tools, these must be done before presenting the regulation. Otherwise, it may not be able to successfully enact or successfully formalize or successfully materialize its initiative into law. Well, maybe it can do that by pushing the legislators, but however, the operation of that institution, enforcement of that institution may not working very well because the public may not accept the KFTC's approach, competition laws approach. So I think the second lesson from the Korea's experience is that, yeah, consensus building approach is really needed. It's really necessary. It's because it's a sector-specific regulation, right? It's not about just economics. It's not about the competition law. It's although of course competition law can be sometimes used or abused in a certain political way, but compared to competition law, I mean the regulation is totally different. It can be captured by the public and by a certain group of stakeholders, and also the pushback by another stakeholders. So it's really difficult to make that regulation works in the reality. So think considering the whole context, I think the competition authority should be really careful in making any initiative. And third one, yeah, that's it. Let me just briefly says that, yeah, even if the regulation is really needed, yeah, I just correctly mentioned in the second point, yeah, the consensus building approach is really needed. And third one, maybe really simple. I mean, market context must be considered. And that's all I can say. Yeah, maybe for the three questions I have. Did I answer sufficiently? Or?
Yeah, you've really answered sufficiently. And I just had one follow-up question on the pushback, because I didn't even know, but now I know that when it comes to the search market, Google is not the dominant firm in Korea. You talked about Navea and also Kakao also being a dominant firm when it comes to the tax alien industry. And my question is, did this pushback come from the big local digital platforms more?
Very. You mean has the local platform operators pushed for the regulation?
Yeah.
To get regulated, or
so like when I look at the market context, and like in Africa, I would say that the US big tech companies have more market shares or are more dominant. Here we can observe that, for example, in the search markets in Africa, Google is the most dominant, but in Korea we can see Navea, I don't know how to pronounce it, being the most dominant. And I was thinking whether the pushback from the local big digital platforms had more influence on KFTC regulatory approaches.
Yeah, if I understand correctly about your question, I think has the dominant platform other than Google and Apple pushed back against the government initiative? Unfortunately, yes. Yeah, I mean, yeah, they lobbied a lot, and then they have a lot of resources. Of what they are really not happy with the regulatory approach by the government, so they really pushed back against. And as I mentioned earlier, the Korea passed the bill, passed the App Store Act. You remember that? I mean, the KCC can sanction using the tool, sanction the Google and Apple. When the KCC and the Parliament and the Congress, National Assembly passed the App Store Act, Naver and Kakao, those two companies didn't push back against the bill. I mean, they were really happy with that because Google and Apple, their competitors, will be regulated by under the regime. So they were really happy with that. But this time, the government announced that we're gonna regulate large companies, including Naver and Kakao, and they were really upset about that against the platform. And so, but yeah, that's maybe one of the also the important point that why the government should be really careful. I mean, it needs to focus on facts. Otherwise, it can be captured by the local companies or global companies. So you will lose where you are. So you have to always be awake. You have to be really careful, and then try to focus on the facts, and then whether the market is distorted or not, and whether consumer welfare is harmed or not. And so yeah, that's what I can say. And
okay, thank you so much. I don't know if anyone else has a question.
Vela, maybe can you hear me?
Yeah, I can hear you.
Yes, and my apologies. I'm driving. I could not see the raise hand button. Thank you, Sangyun. I think it is very interesting. I have just one comment and a question. On the comment, and I think you already touched about that. This approach of the unfair trading practices and also using other tools to regulate the market from a business to business perspective, and not maybe requiring all the time these very complicated analysis, economic and legal analysis, as we apply for measures and for abuse of dominant position. I think it gives a lot of lessons to learn from young African jurisdictions that don't have the capacity yet, and that are building that capacity. So very, very interesting from the Korean and Japan experience. My question is about the abuse of superior bargaining power, or abuse of economic dependence as applied in Korea and Japan. I know, I think you said in Korea they borrowed a bit from the German Act. So just to know, what are the maybe important legal tests that these commission authorities use to apply these provisions, and what are those in the different competition act. So if you can just elaborate a bit on that, I would be grateful. Thank you.
Thank you very much for your comments. And can I just directly answer to Bella? Can I just say directly? Okay.
Yeah, you can answer him directly.
First, I really thank you for your really precious comment. And the second, when it comes to your question, yeah, it's a really big question, and you made a really right point. It may not be really easy for the other, and also including Korea and Japan's authorities, not be very easy for them to use a really appropriate legal test to find out illegal abuse of a superior bargaining position, because unlike abuse of dominance, abuse of superior bargaining position is a little bit very subjective, and then can be abused by the competition authorities. And as far as I know, Greece once had a similar provision, but it suffered from a large amount of complaints who were inspired by the concept of abuse of economic dependence, because the complaints, they thought themselves that we are dependent on a certain company, so we deserve the protection of the abuse of a superior bargaining position. So they removed this provision to the unfair competition law instead of the competition law. So it was really interesting, and so I think you made a really right point. What I want to say here is that it's not it's just still evolving in Japan and Korea as well. But what I can share is that in Japan, there is a case, as far as I remember, that the predictability is really important. I mean, using the superior bargaining position, one company can change the terms and conditions in a really discriminative way. I mean, favoring its own services or other competitors, certain competitors. But in this case, the subordinated party, if they have they were able to predict such changes in advance, then it perhaps could be seen okay in terms of abuse of a superior bargaining position, which means that the predictability of such sudden changes of a company, subordinated company, is considered as one factor to find out abusiveness of the abuse of the superior bargaining position. And second is the spreadness, wide spreadness. And only one company is a victim of abuse of the superior bargaining position may not justify the enforcement of the competition authority. So competition authority checks that whether there were so many victims in the market, then it can assume that the really abusive, the problematic practice is affecting the market mechanism, which means, I mean, if the market mechanism works really well, it may not have happened. There may be the competition authority's perspective. So if a certain problematic practice is really already prevails in the market, prevalent in the market, then the competition authority can sanction the practice as an abuse of a superior bargaining position. And theoretically, even if there is a certain company damaged by the abuse of a superior bargaining position, it can be sanctioned when the market coverage is really huge, and when there is a possibility that this can be a sample of the violation of a superior bargaining position holder's rule. You know, there is a really strong company, and then there may be one or two companies that doesn't follow its strategy, and then it can just resist. And then okay, you are an example. Okay, let's you get the hammer down, and then the other companies may be really shocked by that by the punishment. So in this case, abuse of a superior bargaining position is exploited against the one or two companies, but its effect may be prevalent in the market. So in this case, competition authority can also intervene in the market. So I have explained that the first predictability, and the second, the widespread needs, and second, maybe the gravity of the damage stemmed from abuse of a superior bargaining position in question. And well, fourth, if you look at the Korea's Court of Justice's case, then you will realize that the court considers whether this practice is acceptable from the perspective of social values or something. But yeah, let's just put aside this issue. And then anyways, yeah, what I can say is that it's really difficult, but I think it works really well, and it is not impossible to make a really appropriate test. We are in the process of developing appropriate tool and elaborated the current standards. So yeah, I mean, yeah, I hope this would be a really enough answer to your question. Sorry.
Yeah, so thank you. Very useful. Thank you very much.
Thank you very much. And
Okay.
one more question.
No,
Yeah,
I was just sharing your articles and your blogs, so that
very good. Thank you very much. How kind of you.
so that you can listen. So we are now coming to the end of the session, and honestly, we have a question still.
Wait, Kumar. Yeah, she or he mentioned about the KFTC's guidelines and the relationship between the guidelines and the current proposal. Yes, I think, can I just directly mention very briefly?
Oh, I thought you had answered that. Okay.
Yeah,
You answer him, yeah.
The KFTC prepared guidelines, And then, based on the guidelines, the content of the guidelines, the KFTC recently proposed a law, as you correctly know, that it reversed the burden of proof of dominant position and anti-competitive effects. But the problematic practices have already, as you know, clarified in the platform guidelines. So it just borrowed the types, categories of the practices. But in the platform guidelines, there were no legal presumptions. So yeah, you know correctly. So that's my answer. I'm sorry. Okay, I'm done speaking.
Okay, thank you. So just what I wanted to say is I always note down the key takeaways, and one of the key takeaways I've noted that there's need for consensus building. So the competition agencies or other agencies should not take a unilateral approach where they just want to come and impose legislation and regulations on digital market regulation without talking to the main key stakeholders. And one thing I noted from all the discussion, the key stakeholders do not only involve the businesses, the platforms themselves, the consumers, but also the politicians. So as you've noted is now that the KFTC has amendments on the legal presumptions of dominance, but the opposition in Korea wants the KFTC to be more stricter and to have a legislation on digital market regulation and not to take the soft approach. So it's really important that if you're going to have a good regulatory framework, especially in Africa, we should also consider the political consensus of the day. And also the issue related to interagency conflicts. As we all noted when Dr. Lee was talking about the cases, which is the Korea Communication Commission having conflicts with the KFTC on who should regulate competition issues within the in-app payment systems. So, and the other key takeaway is whether there's a market failure, the market conditions, the market characteristics, and that means competition agencies have to, first of all, at least do a market inquiry, a market study, and justify whether they are going to have regulations that are limited in scope to specific sectors, or whether they're just going to have the entire competition law applying. So the final question as we close is that I would like to know, despite all these legislations being adopted in Japan and Korea, in summary, how would you define the goals of these digital market competition regulations? So for EU, it is fairness and contestability. So how will you define, let's say, Korea's digital market regulations goals? What is it?
Wow.
Yeah.
It's a really big question.
Yeah, that's why it's a final question as we close.
Yeah, maybe I think the fairness is really important. Well, economic efficiency, allocative efficiency has been playing a really significant role in the realm of competition law, as we all know. And at least since the 1970s, with the arrival of the Chicago School in the United States, they have impacted a lot on the enforcement of the competition law. So no one can deny that they have made really good points. We have to be really careful when make an enforcement. However, we may have been missing a really important part of our society. The competition law also need to serve the people. Of course, I'm not saying that competition law should be politicized or it should be abused as the government wants. But I don't want to say like that. But no matter how, I mean, we can just set the right enforcement priority, or we can adjust the enforcement standard, or we can pursue different policy goals. I mean, other than the consumer welfare in a narrow sense. Everything may be worth considering, but what I can say is that just sticking to the economic efficiency may be really dangerous, especially in these days. Everything is polarized, and so many people are suffering from the inequality. So I believe anyone agrees with my opinion, and I'm just following the others' opinion as well. I mean, fairness, no matter what actually it means, that we have to keep this in mind, that distributive justice is also important. How and to what extent you reflect this value into the enforcement of competition law is a little bit different question, but having keep this in mind is really important. That's what I want to say. And thank you for your really brilliant question.
And with that, we come to the end of today's session. Thank you so much, Dr. Lee, for this opportunity.
Thank you very much.
I don't know how to thank you. Just to say, we've really learned a lot from you here. And we look forward to implementing your recommendation in the African context.
Thank you very much. Thank you very much. And thank you for, thank you all, for coming here. Thank you very much.
Thank you so much.
Can just close.
Could you stop recording from your end?
Okay. Should I do that? Or...